Sure.
My name is David Law, and I'm an associate here at the Denver office. Been at Holland & Hart since January of last year, and prior to that, I worked at a plaintiff's law firm where we had a lot of plaintiff side labor and employment issues. So I switched sides and came over to the good side or the bad side, depending on your but yeah, we work on a lot of labor and employment issues around family and medical leave, and this is a big one, Family Act that's coming up. So I'm going to be talking about Family Act generally, covering the entire law in a pretty good amount of detail. I will say this is a developing area. The Family Division is still issuing rules on this and expects to issue some additional clarification. Sure. The portals online, we'll get to that in the presentation, but there are portals that are still being created, forms that are still being uploaded. So there are a lot of moving pieces here. This is based on what we have so far. Also, we'll touch on the HFWA, Colorado's paid sick leave law. There are a few updates to that at the end. Okay, so regarding family, we'll cover what is family leave, how the program works, action items for you all to take now if you haven't already, retaliation and interference, how to avoid those issues, and then cover some of the nuts and bolts. We'll talk about private plans and how family interacts with other forms of paid leave. And then at the end, we'll talk about the paid sick leave law, as well as the updates that go into effect here in August. All right, so as Misty mentioned, there's a lot of text on these slides. They're not necessarily going to be slides as we go through, but they're not intended to be. They're more intended to be a resource for you all afterwards that hopefully you can refer back to when you have questions on this stuff. Okay, so family leave is paid job protected family leave. Starts on January 1st of next year. It's available to pretty much all Colorado employees. There are a few exceptions for folks that are self-employed. Local governments can opt out, but really, in effect, I think for us all here, it really should apply to everybody. That being said, there are a few different ways to comply with it. You can either participate in the state-run family program. You can get a fully insured plan through a private insurance carrier, or you can go with self-insurance. We'll talk about the latter two options later in the presentation. The first option, the state-run family program, is what most employers are probably going to go with because it does seem like the simplest option. Essentially, the division administers everything. As we'll go over later in the presentation, the private plan and the self-insurance options are, it's a nice way to put this. It seems like the division has intentionally made it very difficult. There are a lot of requirements, a lot of hoops to jump through. And even if you satisfy all of those requirements and you successfully get approved for private plan, the division is going to maintain a very close scrutiny over those plans. So it seems to me, having studied this a lot, it looks like the state-run family program they're really trying to push folks towards that. Okay, so under the state-run program, the division will process applications and pay benefits and inform both the employer and the employee when benefits and leave are approved. The employer can require notice. We'll get to that a little bit later in the presentation. Can require the employee to let you know when they want to take leave. But there are some limits on that. And then lastly, it's funded through a combination of employer paid premiums and employee premiums. Okay, eligibility. Essentially, as I mentioned, it covers all employees in Colorado who have earned at least $2,500 in wages in the last year. They say they're subject to family premiums, and essentially what we mean by that is they've earned $2,500 in wages for work performed in Colorado. If you have a weird one-off situation where somebody works remotely in a different state, but or maybe they work remotely here or something weird like that. You can certainly ask me later about that. There can be some weird situations where folks in other states could potentially have their wages subject to family premiums. It's really, really rare though, and not likely to happen. Generally, employee is pretty straightforward. It's an individual who's performing labor or services for the benefit of another. Number one and number two there describe somebody who's not an employee, an independent contractor. The classic examples would be a plumber, an electrician, somebody who comes to your house to repair something. That person is not your employee. They're there to perform set services. Hopefully you're not standing over their shoulder watching them and directing their work as they do it. Maybe you are, but I don't think that's how it's supposed to work. So those folks are 1099 independent contractors and generally are not count as employees. Having said that, do keep in mind that the division has a very broad definition of employee. A lot of the questions when I was listening to some of the webinars that are available online had to do with, well, you know, I have somebody who's on a 1099 or I have somebody who I classify as an independent contractor. The division repeatedly said, we don't care about their IRS classification status. We don't care about how you classify them. All we're going to look at is this test here to determine whether or not that person's an employee. Even if they're a 1099 according to the IRS, if we look at them and we see that on a daily basis, you are directing, controlling their work, factors that look at on that include, is this person subject to employment policies? Were they given a copy of the handbook? Are they expected to work a set schedule? Do they provide their own tools, their own resources? Do you provide them a computer or do they provide their own computer? Do they set their own hours? Do you dictate certain expectations? All of those things. An independent contractor, again, is going to be somebody more who they need to get the job done. Somehow, maybe there's a set schedule for it or contract, but by and large, they have discretion. An employee is somebody who does not have much discretion over how they do their work. Yes.
Would an intern or like a temporary employee fall under this?
Yeah, good question. Yes, sir.
Temp agency that you use occasionally.
A temp agency, that's a good question. So I would have to look at the specific situation to tell. That individual is probably going to be an employee of somebody.
They are an employee of the temp agency.
Of the temp agency.
But we bring them
Yeah.
in. There's some stuff going on right now where they want to pull them in as an employee of ours.
Right.
It's for any length of time.
And we direct her.
We do
Yeah.
employment while they're there, so that is a little.
Yeah, it's tricky. I mean,
It's
even
tricky.
aside from family, typically temp agency relationships are complicated because of the joint employer
Yeah.
doctrine and that status. And so typically in that context, what they'll try to do is, let's say the temp agency doesn't have that great of a benefit package, but where they typically work, let's say they work in the same spot for 6 months or a year, they'll try to claim that they're that person's employee, right? So they can get the benefits and all that stuff. I mean, I haven't seen it. Obviously, I mean, this hasn't applied, this hasn't gone into effect yet, but that's typically, the concern. But I agree that if they're, as David mentioned, if they're employed by the temp agency, then they would fall under that umbrella.
Temp agency's running their payroll, right?
They're on their payroll.
Right. So if the temp agency's running the payroll, I think the temp agency is going to be doing the deductions here for family.
Okay.
And then that's going to be their burden. It's like any other situation where you have the temp agency come in, we're not dealing with the payroll, we're not dealing with the payroll taxes, you guys are handling that, they'll be handling this as well, or at least they should be.
Yeah.
Even if they're under direction in their policy, like you said earlier, you're giving them.
But so that's a separate analysis in terms of whether they are in fact independent of your operation, right? Or whether they're your employee. And so aside from family, the concern with the factors that David is going through is that if you are directing them, if you are giving them tools, if you are doing all these things, then, putting aside the benefits for a second, you could face a misclassification claim. That's what happens a lot of times in those situations.
Just for purposes of family, though, I think the division's mostly concerned with as long as somebody's paying the premiums and they're covered somewhere along the line, they're probably going to be satisfied more than likely. Thanks, guys. Okay, so a few other notes on this. The structure of the business also doesn't matter. It doesn't matter if it's an S corporation, a C corporation, an LLC, whatever it is. Again, the division is not focused on corporate structure or tax classifications. It's just focused on, is this person an employee? Do they meet the statutory definition or statutory requirements for benefits? If so, through the state-run program, the division will say, you're approved, here are your benefits, you're approved for X amount of leave, and then everything's going to be administered through the website, through the My Employee Plus portal or My Family Plus Employee portal, which has yet to get up and running. The My Family Employer portal is up and running. Hopefully, everyone has had a chance to look at that. If you haven't and have questions about that, we're going to cover some of that later here in the presentation, and I'm happy to talk with you afterwards. Okay, job protection this is an important little qualification or a big qualification. Employees are only eligible for job protection if they've worked for 180 days for you. What that means is that you're obligated to give them family leave if they qualify on day one. It's not like FMLA where the person has to work there for a year and have, I think, 1,250 hours under their belt before they qualify. So you could qualify for family benefits on your very first day. You're not necessarily entitled to reinstatement, though. It is a little tricky, though, that last bullet there, because there are rules against retaliation interference, and those apply to everyone. So be careful if you choose not to reinstate somebody, even if that person's been there for less than 180 days.
But I got a question.
Sure.
So once an employee is entitled to the job protection and the right to reinstatement, are there circumstances like under FMLA to where if reinstatement is impossible, or are there carve-outs like that here under family as well?
I believe so, yes. I think, if I remember correctly, it's preferably the same position or an equivalent position.
Okay.
If that's not available, or if the person's no longer able to perform the essential job functions of the position, that's a problem potentially for that individual, and could give the employer an opportunity to say, look, I'm sorry, this isn't going to work. Said that, we also have to remember the ADA applies here as well, and individuals may be entitled to a reasonable accommodation. A reasonable accommodation never requires the employer to exempt somebody from performing their essential job functions, but it may require some sort of adjustment in how those functions are performed, scheduling, that sort of thing. So, a lot of moving parts. Okay, qualifying events. Family will provide up to 12 weeks of paid leave. So in that sense, it's similar to the FMLA as far as the default amount of leave that's available. However, serious health condition, which is the first qualifying event there to manage the employee's own serious health condition, is defined a little bit more broadly than the FMLA. Serious health conditions defined under family to include pregnancy, just pregnancy, not pregnancy with complications or any other issues, just pregnancy. And so the implications of that potentially would mean that if just being pregnant constitutes a serious health condition, then individuals may qualify for family leave just or before their due date, and may be able to go on family leave before their due date. Remains to be seen how that's going to work, but it's again, slightly broader definition. Family member, these are some of the relationships that are included in the definition of family member. It's fairly broad. I didn't include it here, but it's important to remember that family member includes non-traditional family relationships. Probably won't run into it a whole lot, but if you do, it's a good thing to consult with counsel on. Careful, just keep in mind, yes, always, everything, yeah. It's written by lawyers and, and keep ourselves in business, I guess. But it can be complicated, is what I'll say. So number 3 as well, to care for a new child within the first year of birth or foster placement or adoption, to make arrangements for military deployments. And then this last one is different than FMLA to address immediate safety needs and impact of domestic violence or sexual violence. Yes.
So, sorry, on number 2, the definition of family member, if you exclude all those people who it lists first and just says someone with whom they have a significant personal bond, but who doesn't fall in the first categories, I mean, to me that sounds like a friend, right?
Yeah.
So
Yeah.
like, it sounds like you could take the leave for not just for family, for a friend too, if they really wanted to.
Potentially.
Right.
Yeah.
Because I'm thinking as the employer, you could get in hot water if you question how significant the personal bond actually
Right.
is or require documentation.
Yeah.
Whatever.
Well, yeah, and again, it's probably 9 times out of 10 not going to be an issue because most of the time it'll be for a child or a spouse or an immediate family member. But yeah, if you run into that situation, it absolutely, and I will say, there's other guidance on this. I didn't include it here because the slides are already super long, but the Family Division has posted just a ton of information on their website. If you haven't checked it all out already and you need something to read before you go to bed, definitely check that out. Yeah.
Isn't some of the nuances of this the benefit of having family, being part of the family state-run program is because they have to decide whether or not the bond is close enough to
Exactly.
qualify.
Exactly.
If you're on the state plan, then it's not your responsibility
You get to
to do it.
say,
Oh, that's great.
you guys figure it out. Yeah, whereas, yeah, if you have a private plan, or, well, if you have a private plan, then it's an insurance company handling it for you, and hopefully they have their stuff together. And if you have a self-insured plan, then yes, it would be entirely on you or whoever you hired to figure all this stuff out. Yes.
So, like for FMLA, you obviously have paperwork that you have to submit and all that the employee does that I will fill out for them as an HR manager. Will we have similar paperwork for family leave?
Good question. So again,
Not
if you-
sure.
well, no, if you go with the state-run program, the answer generally is no.
Oh, okay.
What the process is gonna look like, so let's say you go with the state-run program. The individual will need to, the employee's gonna need to notify you at some point,
Okay.
assuming you have that as policy, which you can and you should. I think it's 30 days notice for foreseeable reasons and reasonable notice if it's not foreseeable. So it's similar to the FMLA, it's not a bright line rule, but generally if it's a pregnancy, they should be able to tell you pretty far out, at least in the case. Okay, I'm gonna need to go on leave starting on this date. If it's a sudden medical condition or something unexpected, then you need to look at it and work with them probably. As far as,
30 after as well?
what's that?
Is it within 30 days after they take the leave? Or do they have a deadline? Once
I
it starts?
believe it's before the leave.
Okay.
Yeah, I believe it's before the leave itself. It's 30 days if it's foreseeable. So it's similar to the FMLA in that sense.
Okay.
Um,
But yeah, if it just happens, you obviously
Yeah.
have like,
If it just happens and it's reasonable.
Okay.
But there's no paperwork in that situation. Though.
Yeah.
It's not like the FMLA where you send out these WH forms. You're just essentially at that point, if they don't explicitly ask for family, we'll get to this later in the presentation, but like, let's say they come to you and they say, I need time off because I'm going to be giving birth, or I need time off because my spouse is ill, or I want FMLA leave. They don't mention family. And all of those circumstances, that triggers your duty as the employer to let them know, hey, Colorado's got this great new program called Family. Here is the program notice. I'll show that to you here in just a moment. You can print that off or save a PDF on your desktop. It's just a one-page break room poster type thing. You hand that to them, say, check this out, go to family.gov or whatever the website's called, cdle.gov. They will handle your application and everything. And then essentially at that point, it's on the employee. It's between the employee and the division. The employee then contacts the division, applies for benefits. The division has to decide the application within 14 days, so a very short time frame. And then the division will reach out to you, the employer, and the employee contemporaneously, so on the same day, letting you know whether it's been approved or denied and for how much. Just because 12 weeks is the maximum and 16 weeks is maximum for individuals with complications due to pregnancy doesn't mean that the full 12 weeks or the full 16 weeks will necessarily be granted. It's going to depend on the circumstances. A sprained ankle may not qualify for 12 weeks. Yes.
What about intermittent leave?
Great question. So similar process to what I just described. The division's going to look at the application. They're going to assess the condition. They're going to say, this is what's circumstances. Here's what we're offering. They'll let you know as the employer. It's then on you as the employer to make sure that you're working with that individual and their manager to make sure that they're getting the time off according to what the division has granted. If they're not working with you on that, if say the employee is trying to take more time off or is not complying with the terms of whatever the division has offered, you would let the division know and say, hey, so-and-so isn't working with the order that you issued. They can also, the employee can appeal the decision directly with the division. Again, that's going to be between the employee and the division. You're not involved in that. The one wrinkle I will say, and we'll get to this a little bit later, is a lot of employers are going to want to enable their employees to use PTO, vacation, or paid sick leave to top off their benefits. The reason being is that family is only partial wage replacement. It's on a sliding scale depending on how much you earn, but it's up to 90%. So it's similar to unemployment in that sense, is that you're only getting a portion of your wages. But if you go on family leave and you have some, accrued paid sick leave available, some PTO available, you can give your employees the option of using that to top off or to make themselves whole so that they're receiving 100% of their normal wage rate. Or in order to do that, obviously, in order to coordinate those benefits, you have to have some information from the division. You need to know how much is this person getting. You aren't ever required, and you shouldn't pay your employee more than 100% of their normal wage rate. So you need to know from the division how much is so-and-so getting in benefits. Normally, they won't provide that to you as the employer by default. You have to request it. So you can ask for that, yes.
So once you say, the employee is not working with us, based on what you said, you go to the division to complain, kind of.
Yeah.
They come back and sue you for retaliation?
Well, if you did something retaliatory, like if you fired them.
Complain to the division.
What's that?
You complain to the division that they were not following the guidelines.
Yeah, they would be able to file, I believe there's, they would be able to file a complaint with the division, so sort of a regulatory administrative complaint. And the law also provides for some civil liability as well, which we'll get to. Anyway, apologies, I'm jumping ahead here, but any other questions before yes?
So you said that they have a requirement to allow, let the employer know.
Yes.
This could be going on, they get pushed back, so an employee is applying for a family. They don't let the company know that we get notified. When would we, in a conversation with us, what happens in that?
Great question. And we will cover this in just a moment, but the long and short of it is you can discipline that employee. It's appropriate under the circumstances. You be careful about doing that because, again, they don't necessarily have to come to you and say X, Y, Z and fill out, this specific form. Employers sometimes want employees to do that, to do these specific steps to provide them notice. You can't require them to do that. You have to, require them to provide you some kind of notice. So if they come to the HR person, they say, I need time off because I'm giving birth, they don't put anything in writing, even if it's just a conversation, that's probably going to satisfy the notice. Okay. Moving on. So as we talked about, we will have already covered some of this stuff because I did jump ahead a little bit there. Partial wage replacement benefits, it's calculated on a sliding scale. This calculator here at Family, on the Family website will kind of give you some idea of what those benefits might look like. And last bullet here, as we mentioned, employers can, but are not required to give employees the option of supplementing their family benefits with other available accrued leave. But you need to have that in writing, and we'll get to that shortly as well. Okay, so as we talked about, employees are going to be submitting applications directly to the division using the My Family Plus employee portal. Division is supposed to start accepting applications in Q4 of this year. The employee portal needs to get up and running. As we mentioned, the division is supposed to process applications within 2 weeks and make a decision. It then pays out the employee directly. The only payments that you're making as the employer are to top off the employee's family wages if you're doing that. Okay, there's a lot of text. That's way too small, and apologies, but we'll go through this as painlessly as possible. So the division contemporaneously, as we mentioned, notifies the claimant and the employer. They're going to notify both of you on the same day on the decision of the application. Another point to the notice requirement that we talked about, the employee has to make a reasonable effort to schedule paid family leave so as not to unduly disrupt the operations of the employer, and either one, provide the employer at least 30 days notice of the need for leave if it's foreseeable, like we talked about, or two, provide notice as soon as practicable if the need for leave is unforeseeable or if providing 30 days notice is not practicable.
Does it have to be a certain amount of days to qualify?
A certain amount of days of leave?
Yeah, to be under family.
Good question. I don't think so. I think typically if it was just a few days, if it was really short, you'd probably be looking more at sick leave for that.
But they haven't defined it.
They
Like,
haven't
it has to
defined
be
it,
more
no.
than 7 calendar days.
Not as far as I'm aware. Have you seen anything like that?
No, that's a good
No?
question,
That's a
though.
great question. I never thought about that. I'm always so pleased with the questions that we get. 'Cause-
What she's saying
Yes.
is the employee doesn't want to use their sick leave, does not cancel like FMLA does, right?
Right.
Right.
They may choose to say, I want to do that, and so they can hold on to their additional days.
They could do that, yeah. And the way the law is written, they can't be required to use their sick leave. Give them the option, but you can't require
Or
them
if
to.
they've already exhausted their sick leave.
If they've already exhausted it, yeah.
With respect to the number of days, though, I suspect the family or the division is going to look at the applications in a similar manner to FMLA, right? Is this going to be a condition, serious medical condition that would qualify under family like it would under FMLA? So you're probably not looking at employees who would need 1 day of family leave just because it wouldn't, given the circumstances, wouldn't meet those. Yeah,
That's a good point.
good questions. Keep them coming.
If they're going to a funeral, or they're going to go to see somebody who's sick and they need an extra day off. Because
A funeral's interesting. Is
Yeah.
family covered by funeral?
Family does not cover funerals, however, the
But-
HFWA now does.
But we're not going to talk about that.
No.
Juan's going to talk about it.
No.
I'm talking about
Yeah.
that, just later. Just later in the presentation. Great question.
Last name is law.
Yes, exactly. I'll try my best. Okay, great questions. The employer may require the employee to provide those three things: the anticipated start time, anticipated duration, anticipated frequency if it's intermittent leave. Again, can't be super formalistic in terms of the forms. You can't say because you didn't check box 1A on this form, we're going to just say that you didn't give us proper notice and discipline you. Can't do that. You need to be somewhat flexible with them. But what I would suggest doing is having a form, asking them to fill it out, and then training your HR folks on just how to work with people, how to identify situations where maybe the person's not explicitly asking for family leave, but that's what they're asking for based on the substance. Okay. So going on, as we mentioned, second to last bullet, nothing in that act, nothing in the law prohibits employers from disciplining employees for failing to provide proper notice. And you as the employer can file a grievance with the division. If there's an issue that you become aware of, and you have a good faith belief supported by evidence that either this person is receiving benefits that they should not be receiving, or that they are scheduling leave in a manner that's unduly disruptive to employers' operations. I will give a word of caution on that. The division is very employee friendly. It's very clear listening to the webinars. If any of you have listened to those or looked at the guidance that's out there, it perceives its mission. They perceive their mission as advocating for employees essentially. And if you're going to file a grievance against an employee, be very careful about how you do that, because as we'll get to later on, there are retaliation and interference clauses. I'm not saying you should never do it, but you need to have rock solid reasons for doing it and evidence, because if you miscalculate that and you file a grievance that's not supported, it could constitute interference. Okay, action items for employers. And that first one should actually be December 31st, 2022, I just realized. So that was last year. If you haven't done the first several bullets, definitely want to get on those. If you haven't, I'm happy to talk to anybody who has questions about that later on. By the last day of last year, before January 1st of this year, you should have notified your Colorado employees in writing of the family program. There's a flyer that you can send out. Actually, I'll just show you really quick. I guess I actually don't have it in here. Maybe later on, but you just have to give them notice that, hey, this is coming up. You're going to start seeing deductions from your paycheck here starting January. Back in January, we were supposed to start withholding employees' portion of the premiums. By April 30th, register with My Family, the My Family Plus and portal. And then April 30th, with a grace period through May 31st, was the deadline to remit quarter 1 premiums and wage reports. July 31st is for quarter 2. And then later in the year, the division expects to have the portal up and running. As I mentioned, we also expect some additional rulemaking by the end of the year. Any questions on any of those dates?
Might be important to mention too that the employer has the option to pay it all.
Yes, that's a great point. Yeah, you definitely don't have to deduct premiums from your employees' paychecks. That's optional. You can pay the whole thing if you'd like to actually get to that. Here, let's see, I don't know if it's on this slide. There we go. So this is how you'll do it. You'll do it through the portal as we talked about. I'm not going to go through a lot of this in detail. If you have questions as to which employees you need to pay premiums on, this slide touches on that. Not typically an issue. It's usually pretty clear which employees work in Colorado, but you can get some weird one-off situations with remote employees. And then TPAs, if you use ADP, Paychex, or different TPA, many of those companies are already working with the division to synchronize their operations, which is great. And they should be on the ball. They should be handling all of this for you, but make sure that they are, definitely. Don't assume that they are. So I would definitely suggest following up with them, confirming that they've remitted quarter 1 premiums. If they haven't, they need to do that as soon as possible. And they're on track for quarter 2. The family division, again, is great about offering guidance on all this stuff. Again, it's employee favorable guidance because that's just the way they are. But they have tons of resources available on their website, including resources for third-party administrators on that webpage. So if your TPA has questions, you can direct them to there. Okay, so calculating premiums. If you have fewer than 10 employees, you as the employer are not required to pay any premiums. You are required, however, to collect premiums from your employees' paychecks, 0.45% of each paycheck, and then remit that at the end of each quarter. So essentially, you're pulling the money and then remitting it. As you mentioned, you can, as the employer, if you want, pay it yourself. If you don't want to, for whatever reason, simplicity or maybe just an added benefit for your employees, pay that 0.45 yourself, you certainly may. As a general rule, family doesn't take an issue with you giving your employees more than what's required under the law. For purposes of the 10 employee threshold, I will mention that it's employees in all states. It's not just Colorado employees. However, as far as the premiums that you're collecting, the paychecks you're pulling from, only pulling from your Colorado employees' paychecks. If you have 10 or more employees, it's 0.9% is the total amount that needs to be remitted each quarter. Typically split between the employee and the employer. Again, you can pay the full 0.9% if you choose. That is the limit, the federal Social Security wage cap on which, from which premiums are deducted. The tax implications, as I'll note at the top, I'm not a tax lawyer. I don't know much about taxes beyond what a W-2 is. And so this is from the division's website. Some general guidance here. I won't go through all of that in detail right now, but I will say there are a lot of tax implications with this, especially for the employers that are potentially going to go with the private plan, as we'll get to. I'm don't know if I mentioned this, but all employers, regardless of whether you intend to go with the state plan or the private plan, everybody's required to pitch in premiums this year. They said for 2023, we're just going to require everybody to remit premiums. Next year, we're going to refund, family's going to refund premiums to whoever's got a qualifying private plan. The potential issue with that, though, is that some of those premiums are going to be, for employees who maybe no longer work there. There's all sorts of taxable income potential issues and weird things that come up with that. Again, another reason to potentially go with the state-run programs, they actually, and this is what it says on their website, just remember this, they said that they will go to the trouble of tracking down those employees that no longer work for you if you have the state-run program, because they have to remit that portion of their wages as a refund. Okay, definitely consult with a tax attorney on that, and it's a great opportunity. We have great tax attorneys here, so if you have any questions on that, I'm happy to provide some reference. Okay, so notifying employees. As I mentioned, the written notice of the family program, there's not a specific form you're required to use. Here's a sample email that I drafted. It's not perfect, but it's just sort of a template of what you could send to your employees. If you haven't done this already, you're supposed to have done it by the end of last year. Probably a good idea to just do it at some point, just to let them know. And like I said, it doesn't have to be super formal or anything. What I would do, though, is send this and then attach it. And actually what we did here, I think, is have some hyperlinks to these publications and send it out, let your employees know what's going on. This is the program notice. It's too small to read, but this is what it looks like. It's available on the CDLE's website.
Quick question.
Yeah.
Do you, in your experience in dealing with this, do you know whether TPAs are handling the notice too or not?
That's a great question.
Ours is not.
They're not?
Yeah.
Okay.
Definitely check with your TPA.
No,
I assume that they are. The reason why this matters, the notice, is because failing to provide proper notice can be considered interference. So that can be a problem. So definitely want to get on that. The written notice, as I mentioned, that's first sub-bullet there. It's a separate requirement from this program notice, which I refer to as the break room poster. So you have your break room poster, which, thinking of the traditional office workspace, you have posted with all of your other required labor and employment posters. If you are a largely remote workplace, then you can post it on your intranet or somewhere where it's easily accessible to everybody. Second, you have the separate written notice. The easiest way to satisfy that for new hires is just make sure that your employee handbook is updated to include a good family policy and provide a copy of the employee handbook when the person is hired. Ideally with a copy of that poster attached, which we typically do is we just attach several of the Colorado posters at the end of the handbook, and it's just an extra layer of protection. Also, going back to the question earlier about paperwork, this is kind of be here is like the only paperwork requirement that you would really have as the employer when you are notified that an employee needs family. It's not really paperwork, it's just handing them the notice. You don't have to do that physically. You can send them an email. And again, you don't necessarily have to do it in any specific form. You can send them that email if you wanted to. For ease of just sake of simplicity, what I would do is if somebody tells you that they need family for something, or you are put on notice of reason for needing family leave, just say, thanks for letting me know, attach a copy of the program notice poster, and refer them over to the website to apply for benefits. Okay. So, and again, if you prefer, it's this as well. Okay, retaliation. So,
David?
yes.
Can I ask you a quick question? I don't know if you're gonna cover it, but I'm confused at how, if they can take FMLI and FMLA, and are you gonna cover that? Because what you just put up there, they don't qualify yet, and they qualify a week after they come because they've earned $2,500. They're eligible for FMLI, but they're not eligible for FMLA. How as an employer, and can they later on, when they exhaust their FMLI and they become qualified for FMLA, do I now have to give them FMLA?
That's a great question. We do cover that later in the presentation.
Okay.
What I'll say now, though, on that is that the two programs are meant to run concurrently.
Well, they can't if they don't coincide with the same dates.
Yeah, exactly. And that's the issue, is that we're going to run into that between folks that are taking FMLA this year, between now and the end of the year, or folks that have already taken FMLA this year, and folks that potentially want to take family next year. So we'll get to that, but it's not clean, that's for sure. I will say in the long run, the division wants them to run together, but that's not what
That's
it wants.
impossible.
Yeah, no, I agree. It's not ideal. Retaliation, though, is basically anything that you do or technically refrain from doing, an act or omission that is intended to or could deter a reasonable person from engaging in protected activity. So these are some examples, 1 through 6. Actually, no, excuse me, 1 through 6 are actually examples of protected activity. So these are things that employees are entitled to do. If an employee notifies or talks to other employees about family leave, they send out an email saying, hey, there's this great new program. That is all protected under this, as well as applying for benefits or anything else. Hopefully they're not sending out company-wide emails, because that's just not probably their responsibility. Hopefully you have an HR department that can handle that, but just being mindful of that. If you do have employees that are, sort of chatting with each other about these benefits, that's something that they're probably entitled to do. Examples of retaliation, the first two are fairly straightforward. Adverse employment action, so if you fire an employee for taking family leave, if you demote them, if you discipline them. Number 2 is also straightforward. If you reduce their pay or hours. Number 3 is a tricky one. If you have an attendance policy that counts leaves of absence taken under family as an absence, that can be a problem. The same also applies to Colorado's Healthy Families and Workplaces Act. It's an issue where we've seen some issues come up around that. You need to be very careful about how absences are being classified. If you have somebody who is absent for a sick leave covered reason under the HFWA, or if you have somebody who's absent under family, that cannot count as an absence or occurrence for purposes of a absence or attendance policy. If that goes towards, say they hit 5 absences and that triggers, whatever disciplinary action. If 1 or 2 of those absences was an HFWA or a family leave absence, and you discipline that employee, that's considered retaliation in violation of the act. And so that can be a problem. So the long and the short of it there with that is just be careful about how you're classifying absences, is what I would
You
say.
still do, like you have to call in a certain amount of time before your shift.
Yes, exactly. Yeah. So having good notice procedures in place. Again, the common theme with all of these laws is reasonable under the circumstances. So we know with the sick leave law, for example, I don't think that there's it's not like family where it's, a certain number, because it's short term, it's sick leave. So you don't know, maybe it's the day before is reasonable. Maybe it's, some circumstances right before their shift. Look at it from what is the reason why this person is calling in? What's their health condition? Without getting too much into the nitty-gritty details of what this individual has going on, because you don't want to delve into their confidential medical stuff. But just taking a step back and looking at it and saying, is this reasonable under the circumstances? Okay. Interference is broader than retaliation. It is any act, regardless of intent, that interferes with a right or protected activity under the act. Failing to provide notice is a big one, so definitely want to make sure that you do that. Second one is also tricky. As we were mentioning before, to coordinate benefits, if you want to be able to top off your employees' family benefits with accrued PTO or sick leave, you'll need some information from the division to do that, and the division allows employers to request that information. Be very careful, though, about what you're requesting from them. Do not send in broadly written requests that say, I want a complete copy of this individual's file. I want their medical records. I don't think they actually have this. I want look at their medical records myself. Definitely don't do that. You don't want to look at their medical records because if you have, we'll get to this as well. If you end up getting their medical records or any of this stuff, you have to treat it as confidential medical information, store it in a separate personnel file. So it's better as the employer to just avoid that. Ask them for the dollar amount of benefits, so you know that. Maybe generally the reason for leave. I mean, you need to know if it's for a injury, a surgery, recovery, pregnancy, that sort of thing. If the employee hasn't already told you, they probably have. But other than that, really limit what you're requesting from the division. And a lot of this, I'll say too, is going to probably become more clear in the next 6 months because we're going to get more rules from the division. We're going to get forms. The division's going to put on more webinars. You all in this room, all of us, we're not the only ones that are struggling with all these details. The entire state is. And so listening to the webinars again, employee friendly as they are, it really does seem like the division wants this to work. This is a huge, huge change for the state. It's a big deal. And so they really want it to work. And so they're going to hopefully work with employers to a reasonable extent to be reasonable on a lot of this stuff. We'll see though. Okay. For potential bases for liability, employer liability, broadly speaking, you could have civil liability in the form of a lawsuit filed by the employee, or you could have potentially fines or penalties that are being assessed by the state. The family division is a new division of the CDLE, so it's an entirely new division. They do have enforcement authority. They can come in and they can say that, employer, you violated this part of the act or this part of the rules. We're going to assess this amount in fines. I think down there at the bottom, it's $500 per covered individual for each violation is the fee, or is the fine. Another tricky place for liability here is wage liability to the Colorado Division of Labor Standards and Statistics, or the CDLSS. Yeah, does not roll off the tongue, but the CDLSS. Yeah, you could potentially have wage liability to them. They could come in and assess some fines as well for unauthorized deductions. Going back a couple of slides to the dates that we had on there, deductions are supposed to start on January 1st. If they didn't start on January 1st, you definitely want to get those going as soon as possible. You cannot go back and retroactively deduct from employees' paychecks. So say if you're an employer with 15 employees, so you're over 10, if you had started collecting in January, potentially you would have been able to collect 0.45% of each employee's paycheck for the last 6 months, or however many months we've had so far this year, last 7 months. If you haven't done that already, you can't go back now and do that for January through July. You can start now, but for January through July, you as the employer will have to eat that cost of whatever you could have deducted from the employee's paychecks. If you tried to go back and retroactively deduct from your employees' paychecks, that's considered an unauthorized deduction in violation of the Colorado Wage Act. That exposes you potentially to not only regulatory liability from CDLSS, but also a lawsuit for wage theft, essentially. And so it's not a good thing. Definitely don't retroactively deduct. Fix it if you haven't, addressed it yet. Fix it moving forward, but don't try to go back and recover those amounts. Okay. Nuts and bolts of this. We're going to get to family and FMLA here in just a moment. Family and other forms of accrued leave, and then family and short-term disability benefits. A few general principles to keep in mind. These have just been helpful to me. I don't know if they'll be helpful for you, but it helps me to think of leave and wage replacement benefits as two separate things. So I always kind of mixed those up in my mind and recently started thinking about them separately, and that's helpful. So you can have leave, but not necessarily wage replacement benefits. So FMLA, for example, is a good form of leave. It's unpaid, but it's job protected leave. Now, an employee might have some other form of wage replacement benefits out there, that maybe they have short-term disability, or maybe they can use some form of employer leave that's going to run concurrently to make that paid. Really though, what FMLA is, if you look at it, is just leave. There's no wage replacement. On the other hand, you could have just wage replacement. You could have short-term disability, which is an insurance policy typically between the employer and some private insurance company like Unum. Now that short-term disability policy in itself doesn't provide the employee any sort of affirmative entitlement to a time off. The employee is still going to have to qualify for time off, whether it's under the ADA, the FMLA, sick leave, whatever it is. Look in the handbook and find the policy. But you can use those wage replacement benefits under the short-term disability policy to convert that otherwise unpaid leave into paid leave. So anyway, there's separate things. It's good to think about them that way. At FAMLI combines both. So FAMLI, we have leave on the one hand. It's job protected, assuming the person's been there for 180 days or more. We also have benefits. They're being combined. The state is administering both. Family division does not consider other forms of leave benefits that are available. This was a really common question in the webinars. The employers, a lot of the employers would raise their hands and ask questions. Well, we offer this, or we have this form of leave available, or what if this happens, or what if the employee wants to do this? The consistent refrain that the division keeps coming back to is we're not looking at what you're doing as the employer. This is an interaction between us and the employee. The employee is going to come to us and say, I have this condition, or I'm pregnant and I'm due on this date. Here's my application. And the employer is going to look at it. They're going to see if the person meets the statutory definition for family benefits, and then they're going to either approve or deny it. They're not contacting you. They're not going to get on the phone with you as the employer and call you up and, see what's going on and see what other policies are out there, any of that. Yes.
So, say an employee doesn't want to go on there, decides I'm going to take vacation. You can sign a waiver, because if they come back later and say he was qualified, he didn't offer, would that be something that could be problematic?
Good question. So are you saying like if an employee went on vacation and they also had a qualifying?
Well, let's say they had a qualifying event, but they decided, yeah, I'm just going to take my vacation.
Yeah.
You offered it to them. They said, no,
Right.
I'm just going to use, I don't want to use the family.
Oh.
The option, they opt out of that. But then later on, somebody question, you could look at that and say, did they?
No, you don't have to get a waiver. What I would do in that circumstance is whenever you are put on notice that family may be in the picture, have that poster ready to go. Hand it out and be like, here you go, call the division, check out the website. Have that like automatically ready to go. Anything that could qualify as family, you have then discharged your duty as the employer.
Can you have them sign off that they got that copy so that
Absolutely.
you can, in that instance, you can say, hey, we offered it, but you didn't take it.
Exactly. And they specifically address that in the webinar. Employees are not required to access family. It's the same as unemployment. I mean, you're not required to apply for unemployment. It's a benefit that's available as long as they have the information, the ball's in their court. So, great question.
So then can you reach out to, let's say you get notification from the state's accepted their claim or their submittal, they're going to start paying. Would you then, as an employer, reach out to the state to say, hey, we've already paid said employee for this amount of time, 100% based on PTO, sick leave,
Yes.
whatever that is, and say, although you qualified it, they've already been paid for it.
Already been paid for that. Yes, that is one of the circumstances where you could potentially submit a grievance, is employees are not entitled to be double paid for the same time, or overpaid, I should say. They can't ever, they should not be able to exceed 100% of their normal wage benefits. It's something you should have in your handbook, but the division has said that that's not the way it's supposed to work. So yes, in that circumstance, you would want to do that.
Okay.
Absolutely. Any other questions?
And correct me if I'm wrong, but in a situation where you're providing paid leave and the employees agree to accept paid leave, and then it's going to seek benefits, you can recoup, right, from the division
Yes.
what you paid and the difference between the benefits they were.
The division
Yes.
would pay you for that.
Right. So if you
Interesting.
provide,
If you overpay, yeah.
yeah, if you overpay.
Potentially, yeah. I don't think I cover it here in these slides, but yes, there are mechanisms out there to recover overpayments. You have to be really certain about it. You want to make sure that it in fact is an overpayment, but if you're certain on it, submit a grievance to the division. They're going to have more procedures on how to do that. They're going to be policing the fraud aspects of this very carefully, the same way they do with unemployment. We had a lot of issues with unemployment fraud in Colorado over the last few years. I think family's first focus is going to be getting it off the ground, but then they did make clear we don't want people abusing this. So, questions? An exception to the rule that they're really not going to be checking in on what the employer's doing. Like you mentioned, if the employer contacts them, that's could be an exception if the person's being overpaid. Also, workers' comp benefits. You can't collect workers' comp benefits and family at the same time. You also can't collect unemployment and family at the same time, which would be really weird because family only applies to companies, but that was something they said in presentations. Okay, so really quick, I'm not going to go through all this because we don't have a ton of time left. If you have questions about FMLA as far as what FMLA is, what it covers, who's eligible, what the qualifying reasons are, this slide is a very brief summary of all of that. As we mentioned, FMLA is unpaid and only applies to certain employers with 50 or more employees. Eligible employees have to work for the employer for a certain amount of time. So in that sense, it is different than family. How do they interact? Well, in the long run, as we mentioned, they're designed to run concurrently. However, if we've been looking at these regulations and stuff, it's not quite that simple. So the first thing I'll mention though is again, reiterate the notice thing. If an employee comes to you and says, I need FMLA, or I need family, or I am going to take off time because I'm pregnant or I have a serious health condition, whatever it is, all of those trigger your obligations under family. And if you're covered under FMLA, it also triggers your obligations under the FMLA. So you then, as the employer, have two sets of obligations. We've already talked about how you're going to fulfill your family obligation. You're going to hand them the poster. You're done. FMLA, you're probably already familiar with that. You're going to have them fill out, or you're going to issue those two forms there, the eligibility notice, designation notice. You do still have to process it as an FMLA request because the federal law says you as the employer don't have discretion when you obtain notice that somebody is needing leave for an FMLA qualifying purpose. It triggers automatically your obligation to get that ball forward. So you'll have to process it as FMLA. Fortunately, if you're using a state-run plan, processing it as family is going to be handing them the form. And
Say that again. Somebody comes to me and they're in family, and I've got to enroll them in FMLA at the same, or offer FMLA at the same time.
yes,
Okay.
if you're an FMLA covered employer and if they're eligible.
And if you do, then does that use up the FMLA a bit?
Yes. Yes, good question. And that's why you want to do it, for one reason. So there's a few reasons. The first reason is what I just mentioned before. You have to. Federal regulations don't give, this is a common point of misconception, employees don't have a choice to not take FMLA. And employers don't have a choice to not designate it as FMLA. If the employee experiences an FMLA qualifying condition under federal law, everybody involved has to treat it as FMLA. And so that's the first reason. The second reason is what you just said. It's going to use up their FMLA. So they're going to run
So
concurrently.
doing that, then you're automatically going to have to make up the difference because typically FMLA, you use your sick time or any vacation time you have.
Yeah.
So you would be using that to supplement, you'd be forced to do that, right?
Yeah, so that's a good question. Under the FMLA, yes, you can require folks to use their sick time or their accrued paid time off.
The difference between what they would make and what.
Right. Well, and that's the thing though, is under family, you can't. So
It's optional.
it's optional. So I think in practice, this is gonna, you can no longer require them to use time off, essentially. It's hard to conceptualize. That's an excellent question because I was just thinking of it. You have these two universes. You have family on the one hand, you have FMLA on the other hand. One's federal, one's state. They're both running at the same time. Under this set of rules, it says, yeah, you can require them to use their accrued leave. Under this set, it says, no, you can't.
Has that changed?
Not under the federal law, under the state law, it has. And so in effect, you would not be able to require employees to use. If it's an employee that's on both family leave and FMLA, you could not require them.
Doesn't federal law trump state law?
No, it does not. They run, they're separate universes generally.
I have no choice but to put them on, I have to put them on FMLA at the same time.
You do.
But they haven't changed that statute. It says I can't require use of time.
Right. So let's say it was a situation where the person didn't qualify for family for some reason, but just qualified for FMLA. I can't think of a scenario, but let's say there was. It was just FMLA. Then, in that circumstance, then the traditional rule that you can require them to exhaust or spend down a certain amount of paid leave, that would apply. If they're both applying at the same time, though, there's no way to make it work.
But if you're more interested, what about if they make over $1,000 a week and they want to use their vacation, they want to use their time?
If they want to, that's okay. You
Who
just gotta force-
calculates that?
Yeah, if they want to, it's always okay. Family says you can always give them the option, but you've got to have a signed agreement. And typically the way we suggest doing that is at the end of your handbook, have an acknowledgement form. You'll have that, says I'm an at-will employee, I can be fired at any time for any reason. Just add to that. Also, I'm acknowledging that I have the option of using my accrued leave, with sick leave and paid time off.
I do have one more question.
Yeah.
Is the state
Yeah.
going to get anything from a doctor saying it's legit? Or is it just fill out your paper and submit it to us?
They will get stuff from the doctor directly, which is they get to deal with the fun of deciding all of that in 14 days.
So they are going to get,
Yes.
contact the doctor.
Yes, yeah.
Well, we can't contact the doctor.
No,
unless
yeah,
there's-
definitely don't contact the doctor. If you're the employer, don't call up the doctor and ask if the person.
Yeah.
Be surprised, yes.
Are you going to be talking about the situation where if someone has a baby in 2023?
Yes. Yeah, no, that is excellent. And let me actually see, that may actually be on the next slide. Yeah, right there. Okay, so frequently asked question regarding family leave taken in 2023. The bottom line is, whatever the employee does this year doesn't affect the family leave they use next year. Doesn't matter whether they're using FMLA this year, whether they're using, maybe you as the employer have a handbook policy that provides for maternity leave, parental leave, family leave, whatever. Whatever they're doing this year does not affect what they can do next year. And yes, that will result in some people taking 24 weeks of leave in less than one rolling calendar year.
Well, I have another question.
Yes.
So under family, if someone has a complication with pregnancy or birth, they get an additional 4 weeks. So let's say someone has a baby in 2023 and there was a complication.
Right.
Would they be entitled to 12 or 16 weeks under family 2024?
So if they took it this year, say they give birth this year, they have complications.
Yes.
So they'd be entitled to 12 weeks under FMLA.
Yes.
Assuming we're assuming this is an FMLA covered employer and an employee who's eligible for FMLA. So if those are met, they just get 12 weeks now. Next year, you'd look at the situation again and you would say, what's the qualifying condition? At that point, presumably the complications hopefully have resolved. I mean, I guess if the complications had not resolved, if this was an employee who gave birth later in the year and there were some very serious ongoing complications, the employee, come January 1st, I suppose, could take 16 weeks because again, it's totally separate universe. We're looking at FMLA over here, family over here. Typically though, what we'll see is employees taking more time off for bonding leave next year would be more common. Yeah, great question. Yes.
The FMLI
If,
is,
as a corporation, we qualify for FMLA, but due to employee distances, we don't have to grant it, do Colorado employees, can they still file for family to take care of, say, a parent or something?
So if you don't qualify for FMLA,
Right.
yes, yeah. FMLI, FAMLI, in Colorado applies to all employers essentially, and all employees in the state. The only exceptions are self-employed individuals. So if you're a one-person S corporation, or if you're a local government. Do we have any local governments here today?
Why that would be?
What's
I
that?
said that earlier, and I was gonna, why would the local government be, how can they opt out of something?
Great question. Probably have some lobbyists or somebody there that,
I mean,
They did something. I don't know how they did it. It may be a constitutional law thing. I have no idea.
I mean, but it is common in the benefits space. I know under ERISA, church organizations aren't covered by ERISA, government entities aren't
They
covered by
didn't create
ERISA.
it. Church didn't create the law, the government created it and opted out of it.
Yeah,
Right.
pretty much.
Yeah, no, that's a
And
good point.
and a lot of
But
these
I
folks
guess
are
The
lawyers.
local government did create family, and they're the ones opting out. The state is still.
Yeah.
But it is common in the benefits space for government entities to be exempted from the law.
Social Security.
And
Right.
we're getting low on time. I may go a little bit over. What, I know.
Let's do a
Missy
break
said
and
Yeah. What?
Minutes?
5 minutes?
5 minutes? Okay. Okay, so I think we've actually already covered a lot of this stuff, though. This is just explaining the whole make whole concept. If, an employee has PTO available or has sick leave available, giving them the option of using that to supplement their family benefits. Yeah, actually, we've already covered everything on that page. So everybody will get a copy of these slides if you want to go back and review any of this in detail and ask questions.
David?
Yes.
There's a question that came in online. What is the basis for wages and quarterly unemployment wages?
Basis for wages and quarterly unemployment wages. Well, I know that the maximum amount that can be assessed is the Social Security cap of 160,000. Is that, I'm not sure if I understand the question though.
Basis of wages as far as what the division is going to use to calculate the wage replacement, or basis of wages as far as?
Oh.
I don't have any context. except-
No, that's fine. I think maybe that actually would help. So I think maybe what's being asked is, what are they comparing the person's salary to determine the amount where on the sliding scale they land? The answer is the Colorado average weekly wage, which is available from some government website. I can't remember what it is. If you Google Colorado average weekly wage, it will come up. Publish it. What's that?
It's on the family page.
Yeah, it's on the family page. So just look it up online. They'll tell you. They actually just published a new one for July. So what they do is they compare the individual's wage to that. They say you either make a lot of money or not compared to the average weekly wage, and they make the decision based on that. Sorry, I skipped over that. I'm kind of doing questions as we go. This was designed to be more of an intermission, but it's taking longer than I thought. Okay, so short-term disability plans. You can require employees to use short-term disability. If you have a short-term disability plan, say through a private insurer like Unum or something like that, and the employee signed up for it and those benefits are available, as long as it's in your handbook, letting them know, hey, if you go on family leave, you're going to be required to use short-term disability. That's fine. So, and you would need to look at your policy and check with your insurer on that. There may be reasons why you would want to do that. I can't speculate. It's just something that you can do if you'd like. Private plans, we have a lot of slides here on private plans. We're not going to get through all of these. The bottom line is with private plans, there are a lot of requirements. So if you want to go with a private plan, that's certainly an option. One common question that I get that we've gotten a lot is, what's the benefit of going with a private plan versus a state plan? One thing, if we went through this whole presentation, that you'll see, and the point that I've continued to emphasize, is that it really does seem like the state plan is a lot simpler from an administration standpoint. I haven't looked at the costs. I don't know economically, what the costs would look like as far as what you end up paying for the state plan versus what you'd end up paying a private insurer or doing if you had to handle it through self-insured with a surety bond. So I can't speak to the costs. All I can really speak to is the administrative aspect of it. From an administrative perspective, the state plan seems way simpler. It's just my take on it. If you want to take on a private plan or you want to do, heaven forbid, self-insurance, I shouldn't say heaven forbid, maybe self-insurance is it's a great option for some. It's just, you really want to know what you're doing. There's a lot involved. So I'm going to quickly go through a few more slides here. And actually what I'm going to do, give me just one moment. These are some approved private plans. And all of the details are in there as far as private plans, if you want to do that. So, and certainly feel free to follow up with me if you have any questions. Really quickly, this won't take much time at all because we are out of time. HFWA, this is a summary of what it is. It is permanently on the books as Colorado's paid sick leave law, even though it was enacted in response to COVID-19. Public health emergency leave is no longer available. Technically, that law is still on the books, so if, heaven forbid, we should have another public health emergency someday, that would kick back in, but as of now, it's no longer active. That's really small. Okay, so this is just the formula. This is really just a refresher. This is information that actually include in the handbook. This is really just, this is the handbook right here. This is what you would include, essentially, with some formatting changes. Current qualifying reasons, these are pretty self-explanatory. The employee has a mental or physical injury or needs medical care. The employee needs to care for a family member who has an injury or needs medical care. Same as family leave. Number 3, employee or employee's family member has been a victim of sexual assault or harassment, and it's to seek medical attention or for any of those reasons. Public health emergency is also still in there if that happens. New qualifying reasons. This is the update. The employee needs to grieve, attend funeral services or a memorial, or deal with financial and legal matters that arise after the death of a family member. That is new. A lot of employers have a bereavement leave policy in their handbook already. Hasn't been required up until now. If you want to revisit that and either delete your bereavement policy or shorten it a little bit, that's certainly something you can think about now that bereavement's required under family. And then the last 2 are just closures related to weather. And so essentially what the change in our handbook looks like has been adding these last 3, I think. I don't think that there's much else. That's it. And that's really, I mean, nothing else has really changed with the HFWA. If you haven't already deleted, well, and actually I would suggest not making it, always have counsel look over your changes. And that's not just from, that part of that is obviously we have to keep ourselves, going and everything. But another part of it is from just a risk perspective. You want to be very careful when you're always double check everything. If you haven't already deleted the public health emergency leave section or shortened it to like a sentence or 2, you want to do that. Okay.
The department's been pretty active assessing fines for HFW.
I have not paid attention to that.
Yeah, I think from what I've seen, there's been some publications of some really big fines to some big organizations.
Yeah.
So there is a reason to be careful there.
Yeah.
Having a non-compliant HFWA policy can lead to significant penalties. Just want to keep that in mind.
Yeah, and one of the biggest issues, one of the biggest questions that we run into a lot is general PTO policies. I have a general PTO policy that allows employees to take time off for any reason. Can I use that to satisfy sick leave requirements? The answer is yes, you can. The law specifically allows for that. However, you need to be really careful about that because think about your traditional PTO or vacation policy. It's typically going to say things like, well, you need to provide X number of days of notice, or subject to business needs, we might deny the request, that sort of thing, which are all very reasonable in a PTO and a vacation context. When you try to combine that with sick leave, though, which is a statutory entitlement, has super strict requirements, and really gives the employee a ton of leeway in terms of notice, what they have to provide for documentation, if anything, all of that stuff, you have to be really careful. And so in practice, what ends up happening is if you want to go with a single PTO policy, that's fine. Definitely recommend having employment counsel look that over to make sure that you cover all your bases as far as what's required. And then for training with HR business professionals, just making sure that they're sensitive to the reason for leave. You don't want to get into people's personal medical details, really. You can avoid getting the medical records generally. I would just do that. A lot of employers will ask, can we ask for documentation? And it's like, yeah, you can if it's 4 days or more, but really that can cause more problems than it's worth. Just sort of figuring out generally, is this a health issue or are you going to Hawaii? Like what's the deal? If the person's going to Hawaii for vacation and it's the busiest time of the year and they told you the day before, it's probably reasonable to deny that request or discipline that employee under the PTO policy.
Unless they have anxiety and they need to
Yes, unless they have anxiety and
clear their mind.
Yes, to clear their mind, yeah. No, but if it's a health-related issue though, just keep in mind, one size does not fit all. You need to be sensitive to the reason for the request. Okay, so I've gone over. Any last questions before we wrap this up? Yes.
Medical, we keep a separate file, right?
Yes.
Now, is it still for 30 years after when it ends?
I don't think it was,
Filing
is it
requirement?
30 years?
30 years?
What I known is if you have it in medical records, it needs to be kept for 30 years after they stop working.
Well, I haven't heard 30. It's certainly possible. I know that there is 30 years seems on the longer side. I think it's probably more like 3 or a few years, but I'd have to look at the specific law. That's a really good point though. Anytime you're getting medical records, you have to keep them separate. You can't just put them in with the general personnel file. And what I mean by that is if it's a physical file, if you have a physical personnel file, it is literally a physically separate file. If it's electronic, then it needs to be kept electronically separately.
Do you know, is the state getting the signature on the medical release to handle medical, like?
Oh, for the family?
Yeah, or is
Yeah.
that on us to?
No, none of that's on you unless you're self-insured.
Okay.
In which case, it's all on you, but,
That'd help you.
yeah. You could tell I'm very clearly sold on the state-run program,
To
so.
your point, 30 years is for exposure records under OSHA.
Got it.
Yeah.
Wow, that is a
I
long
was like
time.
30 years.
Otherwise, it's 7 for
30.
medical exposure for OSHA requirements.
And I imagine that might be related to like the mesothelioma.
Yeah,
right?
black
Like,
lung.
mesothelioma, asbestos, like those massive class actions or mass action cases. They've always had record problems, dating back to, time. And so I think that's probably where that came from. That's a really good point.
I really quickly wanted to go back to the reimbursement answer that I had given you. I had answered this question for another client, and I think it's probably actually a few clients. So I found the email, reimbursement of advanced payments. An employer may qualify for reimbursement of advanced payments under FAMLI if the employer pays family wage replacement benefits in advance of an adjudication decision without using employer-provided paid leave. 2, the employee applies for family and medical leave benefits. And 3, the employer requests reimbursement from the division prior to the division's payment of benefits to the employee. So that is an option if you decide to kind of front load benefits pending a decision. It's important to note, though, under the rule, there is a specific risk that employee does not then seek family benefits. If you had front loaded that, they don't seek benefits, we're not going to get reimbursement. So a lot of rules on reimbursements and recoupment.
One question that came in online, can we require a doctor's note for them to come back to work under FAMLI?
Great question. So, fitness for duty examinations, I don't know the answer to that off the top of my head. I'd have to look at that. Do you guys know the answer to that?
I don't, but I would imagine.
Love to speculate, but.
Yeah.
It would be a case-by-case basis. If someone's out sick, I don't think you can ask for a fitness for duty certification.
No, but I think you can.
Yeah,
Yeah.
I don't see why you wouldn't be
If
able
it's
to.
serious health.
Yeah.
Like
I mean, it covers for
their
benefits.
arm or something,
For,
and they're required to lift, I think you can.
I mean, I think it probably has to be tied somewhat to the essential functions of the job, right?
Right.
That's typically the analysis for fitness for duty, but, so I would say that without looking
Or a heart
into it.
condition with DOT driver.
yeah, absolutely.
Right.
Or even, unmitigated sleep apnea or something that could cause them to fall asleep or have a heart attack while they're driving. Yeah, it's always what's reasonable under the circumstances, which is frustrating because it's super vague. But with all this stuff, that's a good way to think about it. Any other questions? Great, thank you.